The State of Ohio versus Lorain Knox. It's case number 17CA011233. Both counsel are present. Each side will have 15 minutes to present your arguments. Appellant may reserve up to 15 minutes for rebuttal. And if you let me know how much time you would like to reserve at the start, I'll keep track of that and let you know as you go through the argument. As you probably know, we do have a YouTube channel where these arguments are posted, so please remain at the podium and keep your voice up. The panel has read the briefs in this matter, so we are prepared to proceed if you want.
May it please the court, Attorney John Toth on behalf of the appellant Lorain App.No. The appellant's brief is two assignments of error. Did the court abuse its discretion in not requesting that the defendant undergo a competency evaluation, and then a sufficiency of the evidence argument. Procedurally, Larry Knox had a bench trial before the trial court. It was a failure to register. Mr. Knox, the story makes a little bit more sense chronologically, but essentially Mr. Knox was in Cuyahoga County, had a case dismissed on the record on October 1st of 2015. At that point, the trial court in Cuyahoga County read him his registration requirements on the record. And one of the witnesses for the trial was actually in that trial court in Cuyahoga. So he's released from Cuyahoga County Jail. Mr. Knox was a longtime resident of 2100 Lakeside. It's the pretty massive homeless shelter in downtown Cleveland, kind of across the street from me out here. So Larry, originally though, his parents were from Lorain. And essentially, starting in early October, the Lorain County Sheriffs receive a tip that Larry's living at his house in DeWitt. It's in Elyria. He sent a letter saying, hey, are you registering? Reminding him that he needs to change his address. Essentially, the testimony presented was that starting in mid-October to November, he started coming to the house in Elyria and eventually staying more and more time. It was a gradual changing of residence. The indictment is for October 5th of 2015. Going on the first assignment of error, the competency, this is a very long transcript for a bench trial, and a lot of that is because Mr. Knox is representing himself. And starting at the arraignment, he would not put a plea in because he was under protest and duress. At one of the first pre-trials, he accused the prosecutor of prosecutorial misconduct. There was a litany of filings that were made pro se, accusing the state of treason. There was UCC filings. There was a civil claim, a random BMV paperwork, and multiple times in the transcript, there was a failure to be able to separate. This is the 8th District Court. Mr. Knox had actually won in the 8th District and had 2 cases dismissed in Cuyahoga County Common Pleas. But there was an issue where it was he separating the difference between this is your appellate case in Cuyahoga, this is your trial court case in front of Judge Russo, Judge McMonagle, Judge Burnside in this case. And what the gist of the appellant's argument is, at what point, where is the line in the sand where the court has to then order a sua sponte competency?
I can't remember if it was in the briefs or not, but was anything in the record about how he was represented in Cobb County? He represented.
Pro se, yeah, and I believe it is in the record where he talked about it, but I can also.
That's fine. That's fine. I just couldn't remember. I thought that was the case, but
Now, years ago, he was also represented on appeal by the Cuyahoga County Public Defender. But yes, he represented himself. And he does do a colloquy in the beginning of the case where he talks about, I finished 70% of college, I'm a Navy veteran, and I have a high school degree. But the issue is, as the case is proceeding, it arguably gets pretty, where you look at the State v. Blakemore, or Blakemore versus Blakemore, arbitrary, unconscionable, unreasonable. At what point does it demonstrate enough where the court needs to order a competency evaluation? I mean, there's UCC filings and there's treason, and it's also brought up in the record. I mean, it's not just something that he's filing pro se motions from county jail. I mean, at one point, I think he sued all of the members of the court multiple times. And where is that line in the sand? Your Honor, I was looking to leave 5 minutes.
5 minutes, I was just gonna ask you.
Yeah, I just didn't
You're at
realize.
10 minutes right now, so
Yeah.
you got 5 more minutes, so you reach that point.
And that was the question, where is that line in the sand where the court has to say, and this is a little bit different situation. It's not like you have defense counsel where you have ethical obligations that you're, as a defense attorney, you can say, okay, I need to address the court and say, hey, we need to evaluate.
Well, let me ask you this, was there defense counsel afforded standby counsel?
He had advisory.
Second.
He had advisory counsel that
Did they
actually,
raise that issue with the court?
they did not, but I think it was the court, actually, at one point, the state actually, the prosecutor in one of the original trial courts asked for an advisory attorney, but there wasn't a very positive relationship. It actually bubbled up on the record, because one of the filings he made was trying to bring in some sort of UCC filing against the advisory council and the trial court. So, and that being said, I don't know what the answer to the competency evaluation would be, but it's where's the line in the sand of, is it unreasonable when you have all of these filings, you have these statements on the record, not to send it to a.
No, the standard is abuse of discretion, correct?
You're correct, but, is it unreasonable or is it arbitrary not to ask him to say, you know what, you need to submit to an evaluation at the county jail? And then when it comes to the sufficiency, the second assignment of error.
Counsel, you're not suggesting that the number of filings and misplaced law is the standard, are you? Because boy, there'd be
Oh, and here.
a
and
lot
I-
of referrals for
Well, and
competency.
that's the thing, it's just not just the filings, but when you're on the record and there's a confusion of the different courts that he's at what point is it raised it to a level where we need to look at something? I mean, and this is a unique case because you don't have, he's pro se, so really arguably the person in the best position is going to be the trial judge. Arguably the state could also, but there's not a very good appellate issue on that. But that's where you have this case a little bit different than maybe when you have a hybrid representation and you have counsel there and they're filing. And the state did ask at a prior hearing to actually have advisory counsel appointed to him because this case was originally in front of Judge James Morales that was transferred to Judge Bellis. And in one of the final hearings, the assistant prosecutor said, can you guys please appoint an attorney for the next time you're coming forward? And just based on those filings, but then the confusion on the record, the under protest, and at what level, at what point does that hit the line in the sand where you need to do something? And then on the sufficiency argument, the testimony here was that this was something gradual. It wasn't all of a sudden that Mr. Knox was left county jail and immediately moved in. The testimony was that as time went on, he would stay a night here, a night there, and then Lorain, which is one of the witnesses that actually lived in the same house with Larry at his parents' house, testifies that sometime in November he started staying there more often, was living in the attic. The date of the indictment is on or about October 5th. And there isn't ever a talk about he was permanently living there. He would come and go days here, days there. Is that sufficient that he didn't change his address to Lorain County to DeWitt Ave?
Counsel,
Yes.
was there anything in the record about, I know there was some indication that the homeless shelter said that they had no record of him living there during that time.
there was a issue there because from trying cases, I've kind of read between the lines that there wasn't a way to lay a foundation for those records. A detective, formerly was Detective Orlando, she's the sex offender register deputy. She would verify records with them that she received from the homeless shelter every 30 days, and there's argument back and forth, but essentially they weren't submitted as evidence, and it sounded like basically they didn't have a foundation for it because they didn't have a social worker from the homeless shelter.
The other thing, you started your argument saying he's a longtime resident there.
Yeah, he actually record stepped. I mean, him and the detective from Cuyahoga County were actually arguing that 10 years at least. I mean, they were going back and forth, and she's like, I know it's 10 years you've lived there. He's like, I know it's, so I mean, it was clearly a record that he lived there for 10 years. And that actually goes along to another line of the competency evaluation. I mean, it was pretty clear that, I mean, he has a residence here, that his parents lived here, but then he's also living in a homeless shelter for 10 years. And I thought that kind of gave rise to another reason to ask for competency. And he essentially, on the record, they talked about the homeless shelter, you basically line up every afternoon and 300 people get to sleep there. And then when you mix it with the things going on in court here, that's part of my reasoning for the court should ask for competency.
4 minutes, 25 seconds.
Thank you, Your Honor. I will reserve the rest of it.
Okay, very good, thanks.
For the last time today, I promise.
15 minutes.
Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. With regard to the competency issue and whether the trial court should have raised the issue sua sponte, again, under an abuse of discretion standard, and as, sorry, John and I shared an office prior employment.
Really not.
So, as John raised, the trial court judge was in the best position to determine Mr. Knox's competency. I guess in a strange way, his ability to aid his own defense, because he was acting as his own lawyer with standby counsel, which incidentally was appointed, I believe the record shows, well in advance of the trial date. In April of 2016, the trial started in September of 2017. I believe that was the same counsel who assisted him throughout. So when you look through that record, it's abundantly clear. Mr. Knox understood the primary issue. The prime issue in the case was whether he was living on or about October 5th, 2017, 2015, at that 701 DeWitt address in Lorain County. And if you read through that record, he's trying in every which way to have witnesses testify that he was not. He knew what the issue was. There were a bunch of filings that we've heard spoken about, but there's a difference between being not competent and just being not correct. And he was just not correct in a lot of the issues he wanted to raise, like the fact that there was not a complaint or a letter sent to him, or the failure of Deputy Berry to testify in the municipal court. That somehow the decision regarding his charges in Cuyahoga County was binding on the trial court in Lorain County, on the Lorain County Court of Common Pleas judge. He's wrong on that, but those are hazards that come with representing oneself and not exactly being able or being aware to identify that those aren't issues. But what he was able to identify, the state would point out, is what the ultimate issue was. And he made an effort to try and disprove that issue, which really predicated guilt or no guilt. The trial court found him guilty. Trial court also found him, or never, I guess, didn't find him competent. It maintained his presumption of competency. Two judges did, in fact, all throughout that bench trial, and I think Judge Carr asked if he had counsel sitting with him, and in fact, his standby counsel described him as bright, and so did, I believe, the judge. They both used the same word, bright, in the transcript. Very bright, intelligent. He had some objections that were sustained during the trial. There was no real irrational behavior demonstrated by Mr. Knox. Was it legally irrational? Yeah, I mean, UCC filings based on the UCC, sure, they appear irrational. But as far as his ability to defend the case during trial, there wasn't any real irrational behavior.
Attorney Murphy, is there anything in the record concerning any prior findings of incompetency
None that, and I
or
was
challenges to his competency in any of the other proceedings?
prior medical opinions, one of the factors for the court to consider none. Mr. Knox boasted about representing himself in Cuyahoga County and getting a case dismissed. And it's something he was proud of, that we'd see him in the transcript.
Again, the court in that case didn't raise any issue of his competency before that trial.
I mean, from the record,
Nothing in the record.
nothing in the record that I'm aware of. He had the ability to, I guess, consult with himself so that he rationally understood what the charges were against him. He knew that he had been charged with failing to register his address here. And he knew from that record, he knew what the issue was that he needed to overcome, that he had to disprove, which leads into that sufficiency argument. Multiple witnesses are testifying that as in October of 2015, so by the timeline, right after he's released from Cuyahoga County Jail, he's seen at that DeWitt address. He's seen there in the early morning hours, the night hours. It's circumstantial evidence, certainly, that type of evidence. But, going from downtown Cleveland and then being on DeWitt by the late evening hours, that's when he was supposedly had to have been at that homeless shelter at that night hour. And to get there in the early morning hours, again, just doesn't make sense. So that's the type of evidence for the court to consider. In addition to the Lorain County Sheriff's Office, who goes to verify the addresses. Deputy Halbert says that they find a sleeping bag, a pillow, some belongings in the attic, and associated with those belongings, or I should not associated, but in proximity to those, is paperwork with the name Larry Knox on it. All indications point to that's where he's staying, residing, laying his head at night. In addition to someone who's actually living in the house, in that residence, testifying, John McGrone did, that Mr. Knox began living there in October of 2015 and spent the night at the house. Even Brian Lalithan testified, he's the neighbor from next door, testified that it took him a month before he realized that Mr. Knox he's living at the residence. Brian gets sent, apparently, I believe the testimony was to a one-year prison sentence. Comes home in June of 17, and Mr. Knox is still living there, was the testimony. So not only, 7 consecutive days, I mean, he's well beyond, he's there for more than about 2 years going on right there, between October of 15 and June of 17. And I addressed the sleeping area, so if the court doesn't have any other questions, the state would ask that the court confirm or affirm the conviction in the case, and find that the court also didn't err in sua sponte, raising any competency issues.
All right, thank you for your argument. And Attorney Cote, you have 4 minutes, 24 seconds left.
Thank you, Your Honor. I just to address the prosecutor. One of the arguments was that the witnesses on the sufficiency. You had 2 essentially factual witnesses, and that was Lathan and then LeBron. And in the testimony here was that actually by LeBron, who actually lived in that house, was that as time went on, in late October, he recognized that Larry had moved in, and then by November, he was staying at home regularly. The sufficiency still comes to that the indictment says October 5th, and I stated that State v. Summerfield. I'm talking about, I mean, it basically goes to the consecutive days of you're intending to reside there. And Summerfield goes a little bit more in depth into domicile versus residence. The argument here is what evidence was presented that showed that, and circumstantially, absolutely, the state will present evidence from the witnesses saying he moved there. But what evidence did the state present to show that he intended to then live there full time on October 5th? Because the testimony kind of asserted that it was kind of like a ramp up. It's one night here, one night there, and then eventually it was more and more. And then back to the first assignment of error, the sua sponte, raising competency. What counsel would like to focus would be that, in the end, understand the nature and object of the proceedings. And undisputed, the transcript does show that there's cross-examination. But there was actually hearsay in the business records that you talked about, the homeless shelter records. There's advisory council, but yeah, he objected to that, and those evidentiary objections were sustained. The issue before that, and this is where we rise, is that well before trial, you had the issues with all the filings that were made, to the point where the state asked for an advisory attorney to be appointed, that Mr. Knox actually don't represent himself just on their own, because nobody really understood where his arguments were. And multiple times in the transcript, we couldn't separate the different courts of appeals and the different trial court levels. So you go back to the standard, the nature and object of the proceedings. He can't actually differentiate what the object of Judge Burnside, Judge Russo, Judge McMahon, Lady District, and the difference between that and this case. And in this case, he's on October 5th. He's in front of Judge Russo, and he refuses to sign the registration requirements. And then the detective, Ola Kisak, formerly Deputy Orlando, actually testifies, I'm in court. The judge is reading him. This is your requirement. You're to register at the Sheriff's Department every 90 days for life. And the judge is the one who actually signs off on it, because he won't sign off. And then having the transcript where he can't differentiate, I mean, he's literally, the judge, as he's dismissing the case, reads him his registration requirements, and months later when this happens, he can't differentiate the difference between the Cuyahoga County and the Lorain County and his appellate cases. I mean, simply, he got out October 1st. After the case was dismissed, he walked out. And he can't differentiate that difference, because, I mean, those appeals were all on Megan's Law, and when the Attorney General was coming in and reclassifying, versus this is just, you have to register with the Sheriff's Department every 90 days. And that's kind of going back to the, understanding the nature and the object of the proceedings. So, and then that's where counsel's pointing to on that issue.
10 seconds.
Oh, wait. Thank you very much.
Thank you both for your arguments this morning. The court will take the matter under advisement and issue a decision, which the clerk of courts will mail to each of you on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website if you want to keep an eye out there. Once again, thank you both for your presentations today.